Come on, 2, 3.
Well, good morning. Welcome back to the broadcast, Retirement Network. I'm Jeff Snyder. This is BRN AM for Thursday, February 3rd, 2022. And our top story today, the impact of the Supreme Court decision on Northwestern's 403B plan. Joining me now to discuss this and a lot more are David Levine and Kevin Walsh. Both are principals with Groom Law Group, an employee benefits law firm based in Washington, D.C. Gentlemen, great to see you. Thanks so much for joining us on the program this morning.
Thanks for having us. We're thrilled to see you as always. And, it's nice to see you in person rather than just be recording a podcast.
Yes. Well, I thank you so much for that. Kevin, let's start with you because the Supreme Court, I think, ruled 8-0, and Amy Coney Barrett, I think, did not vote in this particular case. If I'm correct, you'll correct me, of course, if I'm wrong. But they overturned a lower court decision with respect to the Northwestern 403B case. First, I want to get your perspective on the case and the reaction around the Supreme Court decision.
The case had the opportunity to be monumental in the ERISA space. Had the defense won, the case would have, stood for the proposition that if you're a plan fiduciary and you've got a really big lineup, then you know what? If a couple of the options are imprudent, not a big deal.
Allegedly imprudent, Kevin.
Well, I think even if a couple of them were imprudent, you wouldn't get past a motion to dismiss because you have enough prudent options. So I think the decision is not a big shock. Essentially, what the Supreme Court said is if your primary defense is that you've got a lot of options and that provides a defense against having a couple that may be imprudent, that by itself isn't enough to get by a motion to dismiss. So what's happening with the case? It's going to go back to the Seventh Circuit to evaluate other arguments. And that's where, the case becomes a whole lot more nuanced and you really need to kind of dig into the weeds more. And really in the last paragraph of the decision, the Supreme Court talks about, what the Seventh Circuit is supposed to think about when reevaluating the motion to dismiss. And it highlights the idea that, at the motion to dismiss stage in the ERISA context, courts are supposed to try to separate the meritless goats from the sheep. And that comes from a prior ERISA case. So the idea is, take a closer look at the circumstances that the fiduciaries were under, look at the trade-offs they were making in terms of whether a product had higher fees versus other features, and, take a somewhat, deeper dive than one would in a motion to dismiss in other contexts. So, that's the big case. It's going to come down, the impact of this. A lot of this is going to turn on what the Seventh Circuit does and how other courts interpret it. On its face, it's a win for the plaintiffs, but there's a lot of commentary that ultimately could be helpful for defendants, even though it would have been a much bigger defense win if just having a lot of options was by itself a bar to the plaintiff's bar.
Yeah. David, I want to turn to you because you and Kevin both, and thank you, Kevin, great job on that summary. I mean, I think you nailed it. But David, you're sitting, and you and your colleagues at Groom, I should say, not just you and Kevin, are sitting in these committee meetings. What do you tell clients? You don't have to give us the attorney-client privilege briefing, but what do you generally say to clients about this?
Sure, absolutely, Jeff. And there's a couple pieces. First of all, I think I'll pick up where Kevin ended. You have to see, number one, you have to wait and see. How does the Seventh Circuit Court of Appeals handle this? And also, how do other courts handle this? I think the initial message is there could be some good for defense. The plaintiffs will claim it as a win, so we know that. But if you're in a committee meeting, one of the things that immediately comes to mind is, well, what's happened so far? If I was in a committee meeting today, we've had a couple decisions that have cited the case already and sort of said, we cannot dismiss your claims on a motion to dismiss. It's highly fact-specific. So I would say to any committee, doesn't mean that it is more likely you're going to survive a motion to dismiss, unless you were using the argument as Kevin so well described it as, we have a wide range of investment options, and therefore, if one isn't as good, it's not so bad. Unless you're using that argument, I think the world hasn't changed that much. It's just that the courts are citing this case already to say that. So let's see what the Seventh Circuit says. Number two, What's the takeaway? The takeaway on this process is, yes, litigation is a whack-a-mole game, number one. Number two, in terms of your process, you need to look at each fund. For the Supreme Court has said, it's just like they said in Tybalt, not set it and forget it. You need to look at each fund and say, what is our basis? What is our reasoning? And if you look at most committees, they don't sit there and say, here, we approve a slate. They don't usually do a slate approval. Maybe they approve a slate when they're transitioning record keepers, but even then they walk through and there's analytics on each fund. So I say, let's take a look at our process. Are we documenting the why of why we've chosen or maintained all these different funds at this point? And make sure that we have a process where we're flagging, and most advisors or consultants do, where they say this one is underperforming or a management change or a merger or something like that, and go through and say why this or that. The key is you don't always have to be reevaluating every single one every single time, but it's about a process to show how you decided what to reevaluate, why you didn't just sort of say the big pool was good enough and move on. That to me is the takeaway. And again, as we've talked about on the podcast, Jeff, there's other decisions out there. For instance, there was the Intel decision. And before everybody says that's about alternatives, Judge Koh actually had some really great language in there about, well, what's your benchmark and what should you look to? And I like to bring that up here because it's really important saying, how are you benchmarking in your reports if you're going to make that argument? So you can learn from other litigation about how to improve your process. So I think you weave it into a tapestry and go from there.
Gentlemen, just real quick, these committee meetings are already lengthy, some of them 2-3 hours in length. As a result of all these decisions, and do you see these, the litigation portion, the discussion of what's going on, the process, do you see this actually lengthening committee meetings? Are we talking like 8 hours? I mean, just from that perspective, there's a lot to talk about, not only with this, but also policy. But what about those meeting times?
No, I would say that each committee operates in a different way. There's different levels of delegation inside committees. Also, you're relying on, your prudent process relies on experts. So maybe there is more detailed reporting in some cases. Maybe there's more oral discussion in others. I don't think this necessitates an 8-hour meeting. It does. You could have an hour meeting. You can have an 8-hour meeting. It's about what the overall process is. So to me, what is likely to happen is people will often talk about hot topics in some committees and say what's going on. And maybe their investments, there's some delegation and reporting up. So there's a lot of ways. I don't think it's an automatic. Fiduciary oversight becomes even more burdensome. Kevin, any comments on that?
Well, and Jeff, I think, the meeting itself is one component. And, committee meetings, I think an hour is long enough for folks to talk to each other. I get tired of meetings that last more than that. But a lot of the prep goes in before the committee meeting itself, where the consultants are putting together decks or binders that walk through, a lot of the investment performance. And, committee members tend to be sophisticated and they can review that material in advance and then really use that time that they meet effectively and efficiently and get a lot done in a little bit of time.
Yeah, that's a really good point. Last question, gentlemen, before we go to commercial break. This now is going to be reviewed by the Seventh Circuit. What's the timeline typically for something like that? We're not going to hold anyone to account, but what happens in terms of, is it a month, 2 months, 7 months, a year? What happens there?
I'll predict July.
You're gonna go for July?
I'll go July, but I wouldn't be surprised if I'm off by 3 months.
Yep. It can range. It can vary widely. It depends what goes on with COVID. It depends on what goes on with everything. You never know what the other cases are. We'll have to see.
Okay. Well, gentlemen, I want to take a very quick break. When we come back, we're going to shift gears, talk a little bit about privacy, because regulators and legislators are taking a clearer focus on that. You're going to want to stay tuned right here on BRN AM. Imagine a new television network that will make you richer, healthier, and in control of your financial future. This network is for the policewoman in Nashville, Tennessee, the baker in Dubuque, Iowa, the teacher in Lexington, Kentucky. We want to make the idea of savings in retirement culturally relevant. But what do you see as a defining issue of the midterms, especially for the smaller businesses? I mean, they are the lifeblood of the American economy. Featuring exclusive interviews, current affairs, and docuseries. 33 years old, you retired early.
The philosophy is money only matters if it helps you live a life that you love.
But you got to start thinking about retirement as soon as you get in.
The Broadcast Retirement Network will drive very high engagement with premium partnerships. So this isn't retirement and savings for your parents or grandparents. This is for all Americans. And we're going to change the way you think about money. Welcome to the next frontier of retirement and savings. This is BRN, the Broadcast Retirement Network.
Are you stuck with a low credit score, a credit report and score that's causing you to be denied credit or pay higher interest rates than others for the same things? Then do what Terrence did and call Credit Repaired for your free credit evaluation to help restore your credit.
I started thinking about buying a new house, and my score wasn't where I needed it to be. I called and spoke with one of the representatives, and we just had a good conversation, and I liked what he was saying.
Just one call for his free credit evaluation was all it took to start back on the track to repairing his credit.
I'm seeing the deletions and I'm getting the report, so I know something's being done. It does make a difference to me.
All it takes is one call to get started.
Credit Repair has given me a second chance to have a better credit score.
Don't let a low credit score hold you back another day. Do what Terrence did and make the call for your free credit evaluation.
Call 800-819-4152. That's 800-819-4152. Again, 800-819-4152.
Welcome back. We're talking this morning to David Levine and Kevin Walsh, both of Groom Law Group. Gentlemen, thanks so much for sticking with us this morning.
Jeff, we'll always make time for you.
And we appreciate that. The audience, I know, really appreciates it. David, let's talk a little bit about, or a lot about, privacy. This one seems to really be in the crosshairs of the legislative branch as well as the regulators out there. What can you tell us?
Sure. Privacy is like the movie Groundhog Day. And we're recording this right about that time, so it's a great time to talk about it. It's every year you seem to start over and have some of the same discussions. But things are slowly moving forward, although there probably are going to be 6 more weeks of winter in this topic. So let's dive on in. There's many different layers to this. It's like, as I like to say, it's a tapestry that's full of holes right now. There's a lot of gaps. There's a lot of uncertainty as to what's out there. Right now, you have many states that have been enacting privacy rules. But the question is it an employment and plan related data that's covered or not? That's kind of a gateway discussion. You have to have a gating discussion, because in some cases, employment-related data and plan-related data, and we generally think of plan-related data as fitting inside employment-related data at this point, gets a carve-out. For instance, in California, the CPRA has a carve-out, at least through the end of this year, about employment-related data. So, and that's something that I know Kevin and I are very focused on, because we were involved in the CCPA discussions about getting an employment-related carve-out, and that's a big item. But different states have different approaches. So it's a bit of a 50-state patchwork, and trying to find a more harmonized basis is number one right there. But you have to look state by state and then say, does federal law preempt? And let me pivot into federal law for a moment. Federal law, the land of benefit plans is mainly ERISA, but you've got other regulators out there. You've got the FTC, you've got the SEC impacting certain, like registered investment advisors. You've got all these different pieces. They're all looking at it. They're all studying. There's a lot of discussion, for instance, on cybersecurity, which is kind of that overlapping circle that gets close to privacy. But a lot of the questions are like bleeding in. For instance, the DOL has a very active cybersecurity set of questions that have gone from 10 to 4 pages long now, 10 questions to 3-4 pages long, that is starting to ask more and more privacy questions seeping into that discussion. So you've got that landscape where you're getting questions. You've got litigation where fidelity prevailed down in the Shell case, but we know that privacy and use of data, there's a case against a record keeper, but there's just lots of different cases out there at this point where the plaintiffs' lawyers are coming up with theories. Plus you have Congress. Congress still says we want to do something on privacy, but there still is the divide over things like private right of action. Will there be one? Preemption of state laws, yes or no? I know that a lot of trade organizations out there are focused. We're involved, for instance, in Spark, and I know Spark is very focused on trying to create a framework for how all this fits together. So you put all this together, privacy is still a moving target. It is part of negotiation and a lot of other things. So for right now, we're going to see a lot of discussion, a lot of activity, but are we going to get to a uniform rule of any kind right now? Definitely in February, the answer is no for me. But Kevin, what do you think about all these things?
David, I think you did a great job providing an overview. When we talk about privacy, you look back 5 years and privacy felt like it was a bit of a wild west with, companies using data, however, for whatever purpose. And then we saw Europe with GDPR. And I think in the US, we're now running the risk that privacy is a wild west, but it's a wild west to regulators who are racing in to, lay down their stakes. We saw Virginia, Colorado, California all have privacy statutes that have been enacted. We've seen the FTC put out kind of an advanced notice of proposed rulemaking. It's on their agenda they're targeting this month for having a proposed rule related to privacy. As this happens, we run the risk that we end up with overlapping and inconsistent rules, which could be problematic, particularly in a highly regulated space like benefits, where employers already face a lot of obstacles and costs in offering benefits, that if we have an unworkable quilt, as David likes to say, or a tapestry, as he also says, of regulations, that could be another thing that deters, plan sponsors or employers from ultimately offering robust benefit packages to their employees to enable them to retire and live healthy lives.
So gents, just to kind of close it out, what should I be thinking about if I'm an employer? What should I be thinking about if I'm a financial advisor, investment consultant in the space? A record keeper. We don't have to go into too much detail, but I would think that each of these parties really has to put forth their mindset around data, how they're going to use data, how they're going to protect data. That seems to me very top of mind.
I think right now there's kind of a first issue which would relate to all these groups, which is figuring out who they want the regulator to be. And figuring out if they want to comply with every locality and state having their own rule, or if they want to comply with a federal standard. So, where we are right now, sure, you can start doing inventories. Sure, you can begin coming into compliance with what you think the rules are. But we're almost at a more fundamental step today, which is, is it the right time to engage at the national level? Or do we want to see how the state tapestry continues to develop?
David, your thoughts?
And mine is, if you're like, there is what do you want the regulator to be? And then there's a separate discussion out there of what do you do now? Because it's shifting so fast. I think for plan sponsors, it depends on your market segment, the size of your plan, your corporate philosophy. Some are very much like, I want what my participants see to be narrow. I don't want other services. Some are very open. If you talk to some record keepers, they'll talk about what is the client experience, and you get into debates. Who's the client? Is it the plan sponsor or the plan fiduciaries? Is the participant? You can get into all these debates, but that's the key discussion as to what goes on. Same for the registered investment advisor, and for the employer. Even there's occasional questions that we get even today. I got one yesterday where someone said, "Hey, can we use information that we did here for this other purpose there?" A lot of the time you can, but you have to think about it. So everybody should think about, what is the data you're using? What is the purpose? What's your basis? And how has everybody explained and agreed and thought about it? That's a very high level answer, but every case is so fact specific.
Yeah,
David, doesn't it really come down to the client experience?
Kevin, with you and I, it always does. It does. You and me, yes.
And don't forget those agreements, those administrative agreements that really outline all the services that a record keeper is providing. I know you gentlemen are heavily involved in contracts and things like that. We're going to have to leave it there. Gentlemen, great to see you. Thanks so much for joining us, and we look forward to having you back on the program again very soon.
Thank you, Jeff.
Thank you.
And that wraps up this episode of BRN AM. Have a topic of interest, someone you think we should talk to, they'll drop us a line. And don't forget, for all the information in lifestyle, wellness, finance, tech, so much more in all in one place, check out today's edition of our daily newsletter, The Morning Pulse. Want to search our archives or see our latest content? Well, check out our website, www.broadcastretirementnetwork.com, and our streaming partners like Amazon, Roku, Samsung, and over 100 more. We're back again tomorrow. Until then, I'm Jeff Snyder. Stay safe, keep on saving, and don't forget, roll with the changes.
Waiting here for you to take and drink of. But if you're tired, come on.
Now is your opportunity to co-create content around any topic on the first lifestyle and wellness network. Reach a global audience through our platform and co-own exclusive branded content. All of our programs are available on demand and also as audio-only podcasts, so you can take us on the go. Broadcast Retirement Network, available anytime, anywhere, and on any device.
Are you being audited and do you owe the IRS $10,000 or more in back taxes? Is the IRS threatening to take more of your money? Don't fight the IRS alone. The Tax Doctor is here to help you negotiate your tax bill and reduce your stress. The IRS can freeze your assets and seize your bank accounts, but you can stop these IRS actions. The Tax Doctor will work with you using our years of experience to represent your case to help you get the best resolution under the IRS guidelines. Help is here to deal with the IRS to reduce your stress. We've handled thousands of cases, so we know what we're doing. If you owe $10,000 or more in back taxes, do not call the IRS alone. Call a Tax Doctor now for a tax emergency analysis.
Call 800-224-6439.